Welcome back to NYAY PATHSALA. In today's lecture, we shed light on the concept of suppression of material facts. As we unravel the legal implications of hiding material information, it will help our viewers to understand why transparency is the cornerstone of justice. We request you to join NYAY PATHSALA as we dissect this intricate topic in order to bring clarity to the subject. Our core motive is to understand that suppressing material fact is not only detrimental to the cause of justice, but it is also ethically untenable. No litigant can play hide and seek with the courts, or they can adopt pick and choose method. True facts must be disclosed to the court because it is presumed that the court knows law but not facts. It is often said that one who does not come with candid facts and clean breast cannot hold a writ of the court with soiled hands. Suppression or concealment of material facts is impermissible to a litigant or even as a technique of advocacy. In India, since time immemorial, truth has been the bedrock of justice. But in our quest for justice, sometimes certain facts get concealed. So first, let us try to understand why it is essential not to suppress material facts. The foundation of our legal system is the presentation of the complete truth. When lawyers or their clients intentionally hide critical information from the court, it not only undermines the justice system, but can lead to grave consequences. Over the years, the Honorable Supreme Court of India has meticulously dealt with cases of suppression of material facts. So let's look into some of the landmark judgment. The first case is of SP Chengalavaraya Naidu versus Jagannath, which was reported in 1994, 1 SSC, page 1, paragraph 1 and 5. You can pause here and take note of the citation. This case holds a seminal position in the Indian legal history. Why? Because in this case, the Supreme Court opined that a litigant who approaches the court is bound by both the law of the land and a higher duty to the court to be completely forthright. In this case, it was held that a person whose case is based on falsehood has no right to approach the court. He can be summarily thrown out at any stage of the litigation. And why this is done? Because fraud avoids all judicial acts, ecclesiastical or temporal, as observed by Chief Justice Edward Coke of England about 3 centuries ago. It is the subtle proportion of law that a judgment or decree obtained by playing fraud on the court is a nullity and non-est in the eyes of the law. Such a judgment or decree by the first court or by the highest court has to be treated as a nullity by every court, whether it is superior or inferior. It can be challenged in any court, even in a collateral proceedings. In regard to suppression of material fact, the principle of finality of litigation cannot be pressed to the extent of such an absurdity that it becomes an engine of fraud in the hands of dishonest litigants. The courts of law are meant for imparting justice between the parties. So we should remember that one who comes to the court must come with clean hands. Now, let us understand what is fraud in the context of suppression of material facts. To understand this, you have to look into the judgment of the Honorable Supreme Court in the case of Rampriti Yadav versus UP Board of High School, reported in 2003, 8 SCC 311 in paragraph 13. In this judgment, the Supreme Court has held that fraud is a conduct either by letter or words which induces the other person or authority to take a definite determinative stand as a response to the conduct of the former, either by words or letter. Although negligence is not fraud, but it can be evidence on fraud. The courts in India have always held that no court in this land will allow a person to keep an advantage which he has obtained by fraud. So no judgment of a court, no order of a minister can be allowed to stand if it has been obtained by fraud, because fraud unravels everything. At this point, one should remember that the court is careful not to find fraud unless it is distinctly pleaded and proved. But once it is proved, it vitiates the judgments, contracts, and all transactions whatsoever. So the question is whether suppression in a court of law is in actuality playing fraud upon the court. The answer to this query is given in the judgment of Motilal Sangara versus Prem Prakash, reported in 2013 9 SCC 119, wherein the Honorable Supreme Court observed that anyone who takes recourse to method of suppression in a court of law is in actuality playing fraud upon the court. And it refers to a Latin maxim, suppressio veri, expressio falsi, that is, suppression of the truth is equivalent to the expression of falsehood gets attracted. In this judgment, the High Court had applied the principle that when an infrastructure collapses, the superstructure is bound to collapse. However, as the order has been obtained by practicing fraud and suppressing material fact before a court of law to gain advantage, such order cannot be allowed to stand. So now let us understand the meaning of the phrase material facts. For that we have to look into the judgment of the Honorable Supreme Court in the case of Virender Nath versus Sarpal Singh, reported in 2007 3 SCC 617. In this judgment, the Supreme Court has held the phrase material facts may be said to be those facts upon which a party relies for his claim or defense. In other words, material facts are facts upon which the plaintiff's cause of action or the defendant's defense depends. What particulars could be said to be material facts would depend upon the facts of each case, and no rule of universal application can be laid down. Suppression of material fact, we should remember, is always viewed seriously by the Supreme Court exercising their discretionary jurisdiction. In the case of NYAY Business Enterprises Private Limited versus State of Bihar and others, reported in 2004 7 SCC 166 paragraph number 13, the Honorable Supreme Court observed on suppression of fact that as a general rule, suppression of a material fact by a litigant disqualifies such litigant from obtaining any relief. This rule has been evolved out of the need of the courts to deter a litigant from abusing the process of court by deceiving it. But the suppressed fact must be a material one, in the sense that had it not been suppressed, it would have an effect on the merits of the case. So naturally the question now is that definitely comes to mind is how far and to what extent suppression of facts by way of non-disclosure would affect a person's right of access to justice. The answer to this query has also been given by the Supreme Court in one of its judgments, that is Arunima Borua versus Union of India, reported in 2007 6 SCC 120. In this judgment, the Supreme Court has held that it is strict law that so as to enable the court to refuse to exercise its discretionary jurisdiction if there is a suppression of material fact. And what would be a material fact and suppression whereof would disentitle the appellant to obtain a discretionary relief would depend upon the facts and circumstances of each fact or case. Material fact would mean material for the purpose of determination of the list. Material fact would mean material for the purpose of determination of the lease. The logical corollary whereof would be that whether the same was material for grant or denial of the relief. If the fact suppressed is not material for determination of the lease between the parties, the court may not refuse to exercise its discretionary jurisdiction. It is also tried that a person invoking the discretionary jurisdiction of the court cannot be allowed to approach it with a pair of dirty hands. But even if the said dirt is removed and the hand becomes clean, whether the relief would still be denied is the question. So the next query that definitely comes into our mind is that can suppression of material facts be a ground to refuse injunction under Order 39 Rule 1 and 2 of the CPC? In our screen you can refer to two of the judgments. One is Umaji Satwaji Sheikh versus Ghulam Muhammad Ghulam of the Bombay High Court, where the Bombay High Court has recently held that a temporary injunction can be granted only if the applicant approaches the court without any suppression of material facts. And in this judgment, the court has further reiterated that such an injunction can be granted only if a prima facie case, balance of convenience, and irreparable loss to the person seeking the injunction is established. It is often said that if the plaintiff have not approached the court with clean hands, seeking discretionary relief for granting injunction, in that case, discretionary relief and the discretion is not exercised by the court when material facts are suppressed before the trial court. Unfortunately, nowadays we often see in the court that the litigant or the client, or sometimes the advocates, consult of the rejection of the earlier bail application and makes a futile attempt to take bail in a subsequent application. So the query that comes to my mind, which will help you in understanding this concept, is that can suppression or concealment of pendency or rejection of an earlier bail application can be a ground to refuse bail to the accused petitioner? Kindly listen carefully, because this is a mischief which is going on in some of the courts of the country. If the accused petitioner had suppressed the fact that earlier another bail petition was rejected, or any such bail petition is pending, and there is no change in circumstances, in that event the second bail application can be rejected for suppression of material facts. To overcome this, in many of the courts, the practice now adopted is that it must be mandatorily mentioned in every application for bail, whether it is regular or anticipatory, as to whether such or similar application for bail has or has not been made before any other court. In case the same is not made, then its status must also be mentioned. Why this is necessary? Because this will maintain the judicial discipline, and as well as to avoid difference of finding of opinion. Now let's explore the extent to which suppression of material facts impact writ petitions. The Honorable Supreme Court, in the case of Prestige Lights Limited versus State Bank of India, reported in 2007, 8 SCC 449. The court has observed that the court of law is also a court of equity. It is therefore of utmost necessity that when a party approaches a high court, he must place all the facts before the court without any reservation. If there is suppression of material facts on the part of the applicant, or twisted facts have been placed before the court, the writ court may refuse to entertain the petition. And listen carefully, it will also dismiss it without entering into merits of the matter. In the case of Ramsaran versus IG of Police, CRPF, reported in 2006 2 SCC 541, the Supreme Court observed that a person who seeks equity must come with clean hands. We have read this concept in our jurisprudence class. A person who seeks equity must come with clean hands. He who comes to the court with false claim cannot plead equity, nor would the court be justified to exercise equity jurisdiction in his favor. A person who seeks equity must act in a fair and equitable manner. I have shown 2 other cases of the Supreme Court in the screen. You may take note of the citation and go through it to have a more clear concept on these 2 case laws. In the case of K.D. Sharma versus Sale, which was reported in 2008, 12 SCC 481, the Supreme Court have observed that the jurisdiction of the Supreme Court under Article 32 and of the High Court under Article 226 of the Constitution is extraordinary, equitable and discretionary. Prerogative writs mentioned therein are issued for doing substantial justice. It is therefore of utmost necessity that the petitioner approaching the writ court must come with clean hands, put forward all the facts before the court without concealing or suppressing anything, and seek an appropriate relief. If there is no candid disclosure of relevant and material facts, or the petitioner is guilty of misleading the court, his petition may be dismissed at the threshold without considering the merits of the claim. In the case of G. Naraswamy Reddy and others versus Governor of Karnataka, reported in 1991 3 SCC page 261, the court denied relief to the appellant who had concealed the material facts. In one of the landmark cases of the Supreme Court, that is Dalip Singh versus State of UP 2010 2 SCC page 114, the Supreme Court had condemned the practice of misrepresentation of facts and suppression of material facts. The Supreme Court had observed in this case that for many centuries, Indian society cherished 2 basic values of life. Number 1, Satya or truth, and Ahimsa or non-violence. It refers to Mahaviji, Gautam Buddha and Mahatma Gandhi, who guided the people of this country to ingrain these values in their daily life. The Supreme Court observed that truth constitutes an integral part of justice delivery system, which was in vogue in pre-independence era, and the people used to feel proud to tell truth in the courts, irrespective of the consequences. The Supreme Court has repeatedly invoked and applied the rule that a person who does not disclose all material facts has no right to be heard on the merits of his grievance. In the screen, I have given a list of some of the citations of the Honorable Supreme Court. You can look it into as a research work for further understanding the circumstances in which the Supreme Court has looked into the case from the point of view of suppression of material facts. For paucity of time, I will not read those judgments. To conclude, we all must remember suppression or concealment of material fact is not an advocacy. It is a jugglery, manipulation, maneuvering or misrepresentation, and which has no place in equitable and prerogative jurisdiction. Drawing inspiration from the profound words and judgment which I have referred herein, NYAY PATHSALA has taken this proactive step to educate both lawyers and litigants on the essence and importance of complete transparency before the law. We sincerely hope that our efforts through NYAY PATHSALA will further the cause of justice and ensure a more informed and transparent legal community. In the vast realm of justice and jurisprudence, understanding these intricacies of law goes beyond mere theory. So join us in this enlightened journey where life meets law. If you have found value in our content, please consider subscribing to our channel, because it is your support which fuels our mission. I thank you all for joining us at NYAY PATHSALA, and I sign off for now. And again, a big thank you to everyone who watches our videos.